of the census of 2006. I want to say this, last Ceann Comhairle, that there have been a great deal of myths put about in public about this legislation, about what it is and what it is not. In short, what it is an attempt to regulate new families who need protection in our law, who want to put in place protection for themselves and their partners in a way that gives some certainty. And as I said at the outset, that makes eminent sense to me and to the state to ensure that we encourage people to do that, that their affairs are in order, that there is protection given to them. Some of the most outrageous examples I've heard of this, a gay couple or a lesbian couple in a long-term relationship not being recognised in our hospital system, for instance, as the next of kin, not being recognised as the person who has made a long-term loving relationship to another person, an absolute scandal. Another appalling example, someone in a very long-term relationship finding their partner dying and then left with no protection in the context of pension provisions or in the context of law. So I mean, this isn't just about the extension of rights to those couples. It is also about the extension of responsibilities. That what we're saying in the context of the law is that a whole group of people, yes, it is important that your relationship is recognised. These are the rights that go with that recognition, but equally these are the responsibilities that go with that recognition, in the same way that we have responsibilities and rights for people in a traditional married situation. But one of the myths that's been put about this bill, that it will downgrade marriage. And in the short period of time available to me, I want to refute that substantially, last Ceann Comhairle. I don't think it'll downgrade marriage at all. The clear constitutional protection given in Article 40 to marriage is an absolute. It can only be changed by a referenda within our country. It cannot be changed by statute or parliament. It can only be changed by a referenda that would take place within our country. And that was made abundantly clear in the remarks of Mr. Justice Dunn in the High Court action that was taken in the Savone case, the case that was taken by Dr. Savone and Dr. Gilligan, in which they attempted to recognise a marriage of their union in Canada in terms of Irish domestic law. And I think it is worth putting on the record what Mr. Justice Dunn said in that case, the case that was taken, which is still on appeal to the Supreme Court, as I understand. But what he said is this, and I want to put on the record, last Ceann Comhairle. He said, I think one has to bear in mind all of the provisions of Articles 41 and Articles 42 in considering the definition of marriage. Read together, I find it very difficult to see how the definition of marriage could, having regard to the ordinary and natural meaning of the words used, relate to same-sex couples. The definition of marriage to date has always been understood as being opposite-sex marriage. How can it be argued that in the light of the prevailing ideas and concepts that definition could be changed to encompass same-sex marriage? Having regard to the clear understanding of the meaning of marriage as set out in the numerous authorities open to the court from this jurisdiction and elsewhere, I do not see how marriage can be redefined by the courts to encompass same-sex marriage. Marriage was understood under the 1937 Constitution to be confined to the persons of the opposite sex. So this in no way, the passage of this bill, in no way downgrades marriage, in no way undermines marriage, because there is absolute and clear protection given in Article 40-41 to marriage as an act between persons of an opposite sex. Now, I'm not saying that in the future that could change, but the only way it could change is if there is a referendum for the people of this country. It is the people who will decide whether that definition of marriage, as expressed in Bronnrock na hÉireann, can change. And I think that is important. So I reject this notion that in some way this bill downgrades marriage because there is absolute and fundamental constitutional protection given to marriage in the context of Article 40 and Article 41. The other myth that has been put about the place on this legislation is this notion that really there should be a freedom of conscience clause. That, in other words, if I am so appalled by the notion of a gay and lesbian couple coming together in the context of having their relationship recognised under civil partnership legislation, if I'm so appalled by that, I should have the right to opt out of the provisions of this bill on the basis that this is in some way runs counter to my view of the world. Now, if we accept that principle, Las Ceann Comhairle, we will be accepting some kind of Sharia law to this country. We will be accepting that religious belief, religious view of the world will dominate over the laws of the Republic. And we cannot have that. We cannot have a situation where a registrar who will be given rights under this legislation to perform a ceremony, if it is the choice, mind you, of the couple concerned, we cannot say that the primary law cannot give a right to a registrar to opt out of that, because they are an officer of the state. And this notion that under freedom of conscience, an officer of the state could effectively be allowed to discriminate against a gay or lesbian couple because of their religious beliefs is, in my view, fundamentally opposed to the existing constitution that provision that applies. And you know, it is worth going back to the Employment Equality Act of 1998, because as members